I'm really interested in how it's done, because, you know, if you were a cynic, you'd have to say it is tick a box. There is very little monitoring because the resources are just not there, as the resources are in the UK. So, not whether you want to comment on that now.
Just briefly, I mean, the historical arrangements, as I say, in about 2000 with the new tax system legislation coming in, was that the tax office would was expected merely to grant and monitor tax concessions. It has found itself by perhaps happenstance in a position of having to undertake a wider range of functions, we have to apply the resources available to the tax office across the whole of the tax system, where we perceive the most risk and advantage consistent with parliamentary intention of various tax laws the Commission administers.
I want to come back on this, so maybe
Could I just ask a question in relation to that in general? We understand that many religious organisations run charitable groups, but if a religious group doesn't have an affiliated charitable organisation, what checks and balances is it subject to?
It is possible for a religious organisation under the law to self-assess.
Yes, I was going to go to that next.
Yes, and if they make that self-assessment, which also then requires that, or allows for them to be exempt from income tax, then they would wouldn't make themselves known to the tax office, wouldn't be required to make themselves known to the tax office. If the nature of their activities in relation to goods and services tax, for example, were below the thresholds for registration, they wouldn't be registered for goods and services tax purposes. If they didn't have employees, or they didn't have any fringe benefits tax arrangements in relation to employees, they'd have no requirement to engage with the tax office in the fringe benefits tax space, and so they may in fact be, I guess, technically invisible to the tax office in any formal sense.
Well, that in a way answers my question that I was going to ask you, and that is, since religions or groups can self-assess as a religion, what quantum, what number of religions are there out there? But you've really given the answer in saying that unless they become visible to you from some of their activities, then you wouldn't know they existed as such. But surely to claim tax exemption, there must be a point where there are tax returns put in and exemption claimed, and so therefore it must be possible to make some sort of assessment of numbers.
If like the tax concession that the only tax concession that could be accessed without an approach to the tax office by a religious organisation would be to self-assess that they were a religious organisation, which makes them exempt from income tax. The practical consequence of that is they don't have to lodge an income tax return, and then if they have no other reason to have a dealing with the tax office in any other capacity, then they have no dealing with the tax office.
But do they have to advise you of their self-assessment?
No, self-assessment is that they self-assess.
So in other words, they're left alone, they have self-assessed, and you don't have any reason to monitor them whatsoever?
No, the legislation doesn't provide for that. They are potentially invisible to us as a taxation entity, or an entity that has an interaction with the tax system.
Thank you. Senator Xenophon.
Thank you, Chair. Mr Hardy, further to Senator Eggleston's line of questioning, that means that once an organisation has a tax-free status as a religion, for instance, and they self-assess, there is no scope to look into the books of that organisation, for instance?
There could be, because an organisation, and not just in the charity sphere, the tax system is premised along self-assessment. If the tax office became aware of an organisation that was self-assessing as a religious organisation, and we had reason to believe that they may have made an incorrect assessment, we certainly do have powers of inquiry to make contact with them and to gather information, and and we might be able to advise them that they were incorrect in their assessment, that they perhaps were not a religious organisation, and in which case they may be part of the tax system in some other fashion.
But if they are classified as a religious organisation, they are invisible in the sense that you used the word invisible earlier, that they're invisible for the purpose of being subject to pay tax. Therefore, you can't look, once they've got the status of a religion, you can't really look behind that.
Once they're a religious organisation or they self-assess, they have no obligation, they're exempt from income tax and therefore no obligation to lodge an income tax return. They may or may not have other interactions with the tax system,
yes.
But if they try to claim exemptions in any other form of tax or concessions, they do need to approach the tax office about fringe benefits tax or GST or other sorts of concessions.
But let's stick to the issue of income tax. The only way an organisation, a religious organisation, would be subject to income tax would be if there was an inquiry as to its status as a religion and that was taken away from them.
Yes, if they were found not to be a religious organisation, they couldn't continue to claim that status, and then you look at them as to what they are. They still may not be a business, for example. They may have no income that is assessable, but they can no longer perhaps claim to be exempt as a religious organisation.
But in terms of, and you would be guided by that in relation to the taxation ruling 2005-21.
Yes.
And in relation to that ruling, it makes reference to a charity being for the benefit of the community. So if an organisation which has tax-free status by virtue of being a religion was charging a high amount for fees, for services, would you look into the, I mean, the fact that fees are charged is not in itself determinative as I understand it, but would you look into the extent of the fees that are being charged, whether you consider them to be reasonable or not?
There's an overlap there between a religious organisation claiming to be exempt but not claiming any charity concessions, and that particular ruling which is more about charity concessions. So there is a slight mismatch of conversation.
Sure.
As for perhaps a charitable organisation, religious or otherwise, that had fees for some of the service it's performed, it's potentially, if they had particularly large, perhaps non-commercially large fees for a particular service, that might be an area of concern for the tax office to look at as to whether their activities were truly charitable.
So you're saying, but what other rulings would we go to apart from this one for religious and charitable organisations?
There's a number of rulings. That's, as say, tax ruling 2005-21, I think you referred to.
Yes.
Tax ruling 2005-22 also discusses some aspects of charity. There are a number I can provide.
Sure. If you could take on those, but also in terms of religious organisations, which is the main ruling that you say would be relevant?
On just the question of religious organisation, there's no particular ruling on that question. It's a particular category in the taxation legislation as to whether a religious organisation, if it is one, can be exempt from tax, and that's a self-assessment option as opposed to approaching the tax office to also be granted charitable tax concessions.
Has the tax office considered giving a ruling in terms of religious organisations, in terms of giving guidance?
No, we tend to provide public rulings where there is a large public demand or uncertainty. We haven't been approached by entities that have found it concerning enough to seek public guidance.
But looking at the issue of charitable status in terms of charity being for the benefit of the community and the cost of services, if an organisation is giving counselling services and the going rate to see a psychologist or a psychiatrist is $200 an hour, say, I'm just picking a figure out of the air, and if that organisation was charging 3 or 4 or 5 times that, would that be something that would be a factor that would be considered?
Potentially. However, of course, people pay often make their own judgments about what they think is a fair price for a particular service, so long as they're not placed in necessarily a monopoly situation of only a single provider, or they're under duress about being extorted, for example, the payment of funds.